All right, hello guys. This is another video lecture. This week your readings kind of shifted gear from the 8th Amendment to the 14th Amendment. The 14th Amendment has a unique dynamic to it in that we have some levels of scrutiny that the court is looking at. There's certain things that are protected statuses, like race and biological sex, and whatever that status is determines how the court reviews it. So for something like race or national origin, we're looking at a strict scrutiny standard where the government has to have a compelling reason and the law must be narrowly tailored to achieve an objective. You can't divide people up on their race and treat them differently unless you have a really important reason, really important, and that law is as narrow as possible to only achieve that objective. Things like gender are under intermediate scrutiny. This is kind of in the middle ground. So the law needs to be substantially related to an important government interest. There are times where the government needs to have the ability to regulate behaviors and laws and things on the basis of sex. There are a few places where the government needs the ability to do that. Anything that's not protected gets this rational basis review, where the government's law is almost always going to win. Well, here, the government's always going to lose. And so I put this up on Canvas today, and I'll be adding this one too. These strict scrutiny rights are things like race, national origin, religion, speech, and alienage. These are all things that are kind of spoken to in the Bill of Rights and the 14th Amendment. The intermediate scrutiny, gender, legitimacy, maybe sexual orientation. I think that this could probably be shifted away though. Strict scrutiny also, fundamental rights, things like voting, access to courts. Everything else is rational basis. Now, the one caveat to rational basis, government always wins unless they act on hatred or spite towards a group. There are times where they have acted and treated children of illegal aliens, those of the LGBTQ class, or those who are mentally ill, with kind of some hatred. You can't be in our parade. You can't have a group home here, despite the fact that we are giving similar licenses to other groups. Those are not okay, even under rational basis review. Okay. So if you have any questions about those standards of review, let me know, because they will be showing up on your exam in some capacity. So the 14th Amendment, the part that we really care about, there are two primary clauses. There's three, but for our purposes, we care about two. Nor shall any state deprive any person of life, liberty, property, or the due process of law, the due process clause. And the second one is deny to any person within its jurisdiction the equal protection of laws. And the bulk of what we're going to focus on this semester is equal protection of the laws. The rest of the text is very long, but we won't be focusing on it too much. Under that equal protection, we largely protect things that are civil rights. We are going to treat people equally and fairly. We are not going to treat people differently. I really like this video, so if you haven't watched it, make sure you watch it. It's a really great way to explain these differences in the types of scrutiny. Also have the chart up there for you. Okay. So starting off with a couple of the cases you guys had to journal for this week. The first one was Skinner versus Oklahoma. This was a state law that permitted Oklahoma to sterilize persons who had been convicted of 3 or more felonies. Skinner was sterilized, and he argued that the law violated his rights. And when we come over here to the conclusion, the Supreme Court agreed that sterilization has to meet a high burden. We generally have the ability to procreate. We are people, and so taking that right away from somebody just because they've committed felonies, and some of those could be low-level felonies, is not okay. The next case that we're going to really talk about is Roe versus Wade. This is something that we are all kind of familiar with. Roe versus Wade asked whether a woman's right to end her pregnancy by abortion is protected, and that at this time in 1973, the Supreme Court determines that yes, for women in the first trimester, the government cannot interfere. Once the child reaches viability, then the government has legitimate government interest. In the second trimester, it's kind of a balance. The government can impose regulations that are reasonably related to maternal health. So first trimester, woman's right is exclusive in its entirety. Second trimester can legislate based on maternal health. Once in the third trimester, where at this point the fetus had to be in the third trimester to be viable, in the 70s, only the state can regulate abortions in its entirety. The law, but there is this important note that the law should contain exceptions to save the life or the health of the mother. So this is still a really contemporaneous issue. We see the courts continuing to litigate this issue out. We very much care about this issue, and in 1992, in Planned Parenthood versus Casey, the Pennsylvania legislature amended its laws to have some new abortion laws have new provisions. Those included informed consent, a 24-hour waiting period. Minors had to have the permission of one parent or permission of a judge. A woman who was married had to have her spouse sign off. And this was, of course, challenged. The Supreme Court again reaffirmed Roe, but upheld most of those standards. And we have kind of this slightly adjusted standard for how we're going to evaluate abortion-based laws. If the law imposes an undue burden, or in other words, a substantial obstacle in the path of a woman seeking an abortion before viability, then it is unconstitutional. As long as it's not an undue burden, then it is constitutional. So in this case, the provisions requiring a minor to have judicial approval or a parent's approval was okay. The 24-hour waiting period was okay. The one provision that was an undue burden was the requirement that a married woman notify her husband. This was considered an undue burden. Because we don't know what other people's marriages are like. She may have been raped by her husband. He may be controlling. He may have thrown away her birth control and forced her to get pregnant against her own will. There are a lot of dynamics and factors that go into play that impact a woman's decision to carry a pregnancy to term. And so this is an undue burden here. Okay, so there's a lot here. If you have any questions about this, let me know. We are going to see we have seen a lot of states adjust their abortion laws in the last couple of years. We've seen some heartbeat laws be proposed, where once the fetus has a heartbeat, it can no longer, a woman can no longer access abortion. We have seen just a lot of changes. So we will absolutely have the Supreme Court at some point taking these issues back up. In fact, I believe they have something scheduled later this year. So, okay. Next case is Loving versus Virginia. This case is from the early 1960s. We have two residents of Virginia, Mildred Jeter and her husband Richard Loving. Mildred was a Black American woman. Richard was a white American man. They got married in Washington, D.C., but their marriage was against the law in Virginia at this time. There was a law called Anti-Miscegenation Statute, which banned interracial marriage. They were sentenced to a year in jail, which was suspended if they agreed to move away from Virginia and never come back. So the Supreme Court in 1967 overturned this law. This makes sense. If we think about our equal protection chart, we have race here as the highest standard. So racial classifications here, who you can marry, you can only marry people with the same race as you. Classifying people based on their race must be narrowly tailored to achieve a compelling government interest. Who you marry is not, government just doesn't have a strong amount of interest in who you choose to marry, particularly when they're saying that Black Americans can only marry Black Americans and white Americans can only marry white Americans. They really cannot come up with this compelling government interest for this issue. And interestingly enough, this kind of this idea sets the stage for later decisions based on LGBTQ marriages. All right, our next case is Lawrence versus Texas. This is the start of the next two cases kind of deal with sexual orientation. Here we have police going into John Lawrence's apartment, seeing him and Tyrone Garner engaging in consensual sexual activity. Texas had a criminal statute where deviant sexual intercourse was criminalized. And they were prosecuted and convicted of deviant sexual intercourse solely because of their partners. The act of sodomy is acceptable for a man and a woman to be engaged in, but not two women or two men. And so Lawrence and Garner both appealed their convictions. It goes to the Supreme Court in 2003. The Supreme Court says that yes, they win. A state cannot make it a crime for individuals of the same sex to engage in intimate sexual conduct. It's a violation of your due process rights. Really, this kind of turns on the fact that the government should not be regulating private consensual conduct between adults. And if we think about this, by and large, we agree with this. We don't want the government in our bedrooms telling us who and how we can love. And so that's really kind of what the court issue this case is. And then in 2015, we have the Chappell v. Hodges case. In this case, we have 6 different same-sex couples suing to invalidate their state statutes and their state's constitutions that say that same-sex marriages cannot be recognized. And they win. The 14th Amendment guarantees us the right to marry as a fundamental liberty. That means that who we get married to is an individual personal decision, and the government cannot interfere with who you marry. The court finds that marriage protects an intimate association between two people. It safeguards children and families. It is legal recognition of your home, your ability to raise children, and that there are no legitimate reasons to exclude same-sex couples from those rights. They also have intimate associations. They build a home. They raise children. There's no justification for treating this group different other than hatred or hostility, which is not an acceptable reason. Okay, so those are the issues in the cases this week. If you have any questions, let me know. Make sure you look over those standards of review because they will be showing up on your final exam. Otherwise, have a great rest of your week.